All right, welcome everyone. Happy Monday. It's another webinar Monday. My name is Rilus Dana. Have another exciting topic today. It's a very important topic today. So today we're going to be talking about what to do after the loss of a loved one. This could be important if you're if you're going to die someday and you want to plan your estate. This will be useful information for that. It's also going to be helpful if you're in the situation where you're helping someone administer an estate, whether that's parents or someone else. So we're going to talk about also if you're the beneficiary. So if you're not the one in charge, the fiduciary, if you're the beneficiary, we'll talk about what you should do as well. So hope you find this helpful. I'm going to share my screen in just a minute here. So let's go ahead, get that out of the way. All right. If you guys have any questions, you can leave them in the comments, whether you're watching live or on the replay. Leave your questions in the comments and we'll get back to them. We may cover them on the next week's stream, or we may do a reply in the comments. So any other topics that you'd like to see us go over, you can leave those in the comments as well. Okay, so there's a thumbnail I did. Got to look like a YouTuber. Got to do something semi-embarrassing on the cover to get more views on YouTube. Okay, so Dana and Associates, that's the sponsor of today's video. That's where I practice law in Arizona and California. Our website's danalegalhelp.com. If you need help administering someone's estate or planning your own, we're there for you. Okay, so what to do after the loss of a loved one. Step one, you got to define the players. So we're going to define the players and a few key terms. Decedent, that's the dead person. The person who's passed away is the decedent. Fiduciary, I use this green hat to signify the fiduciary, the bookkeeper hat. So that's who's in charge, is the fiduciary. And beneficiary, who gets the stuff. So we use this hand to signify the beneficiaries. There could be multiple beneficiaries. What is an estate? So an estate, is it a large house? Sometimes people use that word that way, but in this context we mean an estate is everything a person owns, whether alive or dead. So this person, Mr. Estate, he has a bank account, a house, an IRA, and a life insurance. All of those assets are part of his estate, whether he's alive or dead. So even after he's passed away, these assets are still part of his estate. Fiduciary is a person to whom property or power is entrusted for the benefit of another. That's the definition. There's the symbol, this green bookkeeper visor. So whoever's wearing this, that means they're in charge. That's the symbol that I like to use. Fiduciary duty. So fiduciary duty is the duty that you have when you're wearing that visor. It's a legal obligation of one party to act in the best interest of another. Last will and testament, another term or phrase or something that you should know what it is in order to manage an estate. It's a legal document. The person that makes it is called the testator, and it's a legal document where they name the beneficiaries of their estate. They can also name guardians of minor children and the personal representative to manage their estate. The last will and testament, it's only effective after the person passes away. It's only, it doesn't do anything. It's not controlling anything until the person passes away. If a person does not have, or Uncle Sam here, this is showing what happens if, two things. If a person does not have a last will and testament, their estate is controlled by the laws of intestacy. And also to appoint the personal representative and guardian, they still need to be appointed by the court. So that process is probate. So what is probate? Here's an example of how most people learn about probate. So husband and wife here, Mr. and Mrs. Estate, they have a house. It's owned by both of them. It's in both of their names. She has a bank account just in her name. She has some life insurance that names him, Mr. Estate, as the beneficiary. So after she passes away, the life insurance will transfer to Mr. Estate, and so will the house. But how does he collect this bank account? Still in the name of his deceased wife. So we look at her will and see that it names him to be in charge as the personal representative of the estate. It also names him as the beneficiary. But if he goes to the bank with the will, that's they're going to need more information. They're going to need what's called the letters testamentary, or what they call the personal representative letters, issued by the court certifying who has authority over the estate. And then once probate is filed, the personal representative will be appointed. They'll get their green fiduciary hat. They'll have the responsibility. They'll have the authority to be able to act for the estate. There's several steps that they have to go through, and then eventually they'll be able to transfer the assets from the estate to the beneficiaries. Okay, so we've defined the players. We've talked about some of the terms. Next thing I want to look at is, what are the assets? Is it IRA, life insurance, bank accounts, real estate? So next step after you figure out who the players are what are the assets? And then you want to figure out what controls the assets. So the IRAs and life insurance, a lot of times they have a beneficiary listed. So whoever is listed as a beneficiary, that's where those accounts go. So that's going to be controlling that contract itself that names a beneficiary. The house is in the name of the deceased, so it's it's controlled by their estate, or things could be titled in a trust, controlled by a trust. So with bank accounts, the beneficiary could be listed as a person, or it may be a trust. Okay, so once you figure out what controls assets, so assets in the estate covered by the last will and testament. If there's no, or the last will and testament is going to name the beneficiary, where things are going to go. It should also name who the personal representative will be. Now, if there is no last will and testament, Uncle Sam's got you covered with the laws of intestacy. So that means that's a default order of who the beneficiaries will be. Trust, so if assets are in a trust names the trustee, which is the fiduciary, wears the green hat, and the trust will name the beneficiaries. So if you're the fiduciary, so if you're the one named to wear that green visor hat, what should you do? So first thing, safeguard the assets and start an accounting. The next step is you want to get appointed. So you want to get formally appointed. So if assets are in the estate, that means that you do a probate to become appointed as a personal representative. If it's in a trust, that means that you get formally appointed. We prepare a document called the acceptance of trustee, just to make it clear to the bank that you got this green hat, that you have the authority to act for the trust. And then you also need to report to the federal and state governments to get a tax ID number for the trust and the estate. And then you're going to follow the trust, will, or intestacy law. So follow the instructions, which will either be a trust, a last will and testament, or maybe both of those things. And then also could also be the laws of intestacy. So if there is no last will and testament, or if all the people that are named as the personal representative or beneficiaries have passed away, then we look to the laws of intestacy to see who has priority to serve as the personal representative or who the beneficiaries would be. Okay, fiduciary duty. So the visor. Whenever you're wearing the fiduciary duty visor, you're responsible to act in the best interest of all of the people in there, all the beneficiaries. So legal counsel is recommended to help you interpret that duty and decide what is the best use of those assets. Create subtrust if required. So if there's minor beneficiaries, it's common that things are held in trust until they reach a certain age. Special needs trust is another common type of subtrust that gets created inside of the master trust, or a dynasty trust. So for those, if they're necessary, they also need a tax ID number for each one of those things and reporting to the federal and state government. So after you get appointed, create the subtrust, then you'll need to collect all the assets, determine and pay valid debts. Valid debts is the key part of that. There's a lot of faulty claims that get made against an estate, so it's important to determine what is necessary to be paid, and there's also room to negotiate with some of these creditors. As I remind the beneficiaries or the personal representatives that we no longer care about the credit of the deceased. We no longer care about preserving their good credit. It's about settling for the estate and getting the best result. After all debts have been paid, then it's time to divide the assets. And sometimes I include in this presentation, I say, don't get sued by your siblings. That's the other goal. Don't get sued by any of the beneficiaries of the trust. So the beneficiaries in these documents or these places, that's who you're working for. That's who's going to make sure that you're doing a good job. And if they're not happy, we'll see what they're going to do when we talk about the beneficiaries next. Okay, so what to do if you're a beneficiary. So your parents have passed away, you're not the one in charge, maybe your brother or sister is in charge, but you are entitled to receive a share in the trust or in the will or in the estate. So that means you're a beneficiary. So what should you do? Number one, you should ask for a copy of legal documents and do this in writing. So ask in writing. Text message, that is writing. Emails, writing. A mail, you can mail a letter. It's obviously a writing, but you want proof that you asked in writing. So again, you can prove the text or email. People may try to say that they did not receive it. So a certified letter is a good way to prove that someone did receive that writing. You get the written receipt. 2, ask for an accounting. So you want to know what the legal documents are. So you can figure out who the players are and what you're entitled to. And then you want to see an accounting. So what are the assets in the trust and the estate? And does everything make sense? Be patient. So if you're getting these first two things, if you're getting a copy of the trust and the will and the legal documents, and if they're providing you an accounting in the beginning, at least just a basic one, just giving you an idea of what the assets are that they're trying to collect for the estate or for the trust, then be patient. It does take time to collect these things. So if you are getting information, then you can be patient. Now, if you're not getting good answers, if you're not getting a copy of the legal documents, if you're not getting information about the assets, then that's when it's time to consult a lawyer to advise you of your rights. The lawyer is going to go through some of the same steps. So they're going to ask in writing for things. And if they don't answer and give accounting and a legal documents, then you start asking the question, okay, are you ready to sue your brother or your sister or whoever the trustee is? Are you ready to go down that road? So how should you approach the trustee when it's a family member? Open and honest is always the best. Try to limit your communication to just about the matter at hand. This isn't the time to hash out old issues or who mom and dad like best or whatever it may be. Weigh the desired outcome. What are you hoping to achieve out of this? Do you want to have a relationship with that family member after? Is that likely to happen after a lawsuit? So that's what it means to weigh the desired outcome. What do you hope to achieve by starting litigation? What to do if they don't respond? So if they don't respond, hire legal counsel, set deadlines, and make plans for what happens after deadlines. So if you set a deadline for when you want them to provide an accounting, what are you going to do after that deadline has come and gone? All right, so how to litigate nicely. So try to refrain from yelling and cursing. Try not to get sucked into the emotions and let the situation and the emotions take over, but focus. Have an outline of questions if you are speaking on the phone. Stay organized in what you want to accomplish and stick to those questions. And that's it. That's the end. Okay, so thank you everyone for watching. Again, Dana and Associates is the sponsor, danalegalhelp.com. You can go to for more information about setting up your own estate plan or administering the plan of another. Hope you found this information to be helpful. Let us know what other topics you'd like to hear about on our weekly webinar series, and we'll see you next time.